We are live.
Right. Good morning and welcome back to the House Environment Committee. We are going to take a look at proposed amendments to H 480 for another miscellaneous agriculture bill that has some amendments to it that are germane to our areas of jurisdiction. Welcome, Michael.
Hello, this is Mike O'Grady with Legislative Council. You may remember that when H 484 left the House, it was a bill entitled An Act Relating to Miscellaneous Agricultural Subjects, but it really only related to one subject, and that's the regulation of what are called beneficial substances, which are things like plant amendments, plant biostimulants, etc. The Senate Agriculture Committee added 6 substantive sections and an effective date. And then yesterday on the floor, there was an amendment from Senator Watson to move certain provisions from H 319, the bill that your committee worked on, the Act Relating to Miscellaneous Environmental Subjects, to move them from 319 on to 484. That added about 42 pages to H 484 and moved it from about a 31-page bill to about a 67-page bill, 68-page bill. I did not have the official text of the Senate proposal of amendment until about 9:30, 10 this morning. So I put together a side-by-side of just the subjects. So it's 3 pages long instead of 67 pages long. I can take you directly to any specific text that you want in the Senate proposal of amendment, but why don't we work off of the side-by-side if that's okay with the chair?
Great.
So section 1 is what passed out of the House in 484. It's the beneficial substances amendments. The Senate made no changes to that language as it passed the House. So it's 24 pages of the bill, and I didn't think you needed to go into depth on that. Section 2 relates to pesticide disposal. Currently, when a person wants to sell a pesticide product in the state, they have to file a registration with the Agency of Agriculture, and they had to pay a registration. Registration fee is currently $200. That money, most of it goes into a pesticide registration special fund. And part of what that fund is supposed to do is to be used for the collection of unwanted or obsolete pesticides. And the agency is supposed to work with the solid waste management entities because they're usually where people take back their unwanted or obsolete pesticides. And the solid waste management entities for some time now have been arguing that their cost of that collection of those pesticides have not been met. So the Agency of Agriculture Industry, Primer Piper representing pesticide interests, and the solid waste management entities agreed to propose the increase of the registration fee from $200 to $250, an additional $50. That $50 additional fee will be used specifically for the collection of unwanted and obsolete pesticides to pay effectively the cost of solid waste management entities. In addition, there's going to be a directive, and you'll see this on section 3, that the Agency of Ag, in consultation with the Department of Environmental Conservation, shall study options for sustainable funding to reimburse the SWMEs for all costs associated with collection and disposal of unwanted or obsolete pesticides. That is going to include a recommendation whether or not to have an extended producer responsibility program for unwanted or obsolete pesticides.
Those pesticides, both from kind of commercial farm pesticides, but also household pesticides.
So commercial farms generally have agreements with their dealers, and for the take back of unused or the emptied container. This is more about what's showing up at the solid waste management entities as pesticides that are unused or obsolete. The agricultural one, I'm sure it's going to be part of the study, but the payment right now is about paying the cost to the swimmies who have, I'm sure you've heard of this before from your swimmies, that they're not supposed to be paying all these costs. The statute already says the agency is supposed to be paying for collection of these, and they're not fully. And so this is to address that concern.
Representative Lewis.
Do you know how many companies would be required to pay this additional fee? Approximately?
Well, it's per product, it's not per company.
Oh, okay.
And
Product, I see.
and so then James did a fiscal note about how much additional revenue this will generate. I think it was $900,000.
Okay.
And I can double check that.
900,000 divided by all the swimmies.
Right.
To end up being that much.
And to be clear, this doesn't make Vermont an outlier in pesticide registration fees. We're kind of pretty squarely in the middle. And in New England, Rhode Island's more than us. New Hampshire's a little bit less. Massachusetts is around that 200. New York has a weird system. They don't do it per product. They do it a different way that I don't understand. And so it's not an outlier when you look at these fees nationally and regionally. So then moving on, section 4, you are all very familiar with the 3-acre permit. I think you are also aware that the agency had been working with the agricultural fairs to get them money to help them come into compliance with the 3-acre permit. And 3 of the 4 are moving towards compliance. Rutland, the state fair, has unique situation because of its site conditions, because of the limitations like the railroad, the swamp, the state highway. They don't have the options that, say, Addison does with its land or Champlain has with its extra land. So A&R went down to the fair to review the site. So the secretary and deputy commissioner came in, and they agree that they have unique site limitations, and they're proposing that the fair still get the 3-acre permit and do what it can do on site under an engineering feasibility analysis, but not be required to pay the additional stormwater impact fees or complete an additional offset to technically meet their performance measures under the manual.
And this amendment was added by the Senate Agriculture Committee.
That was added by Senate Agri. They started out with a full-scale exemption for all ag fairs, and the agency came in and said, well, most of the 3 that are subject are already moving towards it and have spent money to do that. Let's figure out something. Let's first determine if Rutland really is unique, and they determined there was, and figure out some way to alleviate some of that cost pressure. Should I move on? Section 5, as I think most of you know, agricultural land qualifies for use value appraisal. Right now, one of the ways that land underneath 25 acres in size can qualify is if you are selling farm crops that generate $2,000 in income in 1 of 2 or 3 of 5 calendar years. But there have been advocates who are saying that they are donating that amount of farm crops, not selling it, and are ineligible for current use because they are donating instead of selling. So the Senate Agriculture Committee amended the use value provision to allow for agricultural land up to 25 acres qualify if they're donating that $2,000 of farm crops in one of 2 or 3 of the 5 calendar years.
You said one of 2 of the 3 of 5?
1 of 2 or 3 of the 5
Okay.
previous calendar years. I probably misspoke. House Ways and Means just asked for an amendment to remove this.
Okay.
They are, I think you all know, they're very concerned about any change to use value and how it affects the ed fund. And they didn't have any time to review this change, and they don't want to go forward with it.
Okay, good to know.
Section 6 relates to a very technical aspect related to the Administrative Procedure Act and to the Department of Forests and Parks heavy cut rule. So prior to 2016, if you wanted to find an agency rule, you had to either be lucky, or you needed a diligent agency, or you couldn't find it. So because there was no uniform way that was required for agencies to publish their rules. And then Representative Jewett, the attorney, it infuriated him. And so he moved that by 2018, all agencies had to publish their rules under a Vermont Code of Rules that the Secretary of State would publish. And if they didn't publish them by 2018, then those rules were repealed. Now, the Department of Forests and Parks, when they first entered into the heavy cut law, both the statute and an emergency rule that would have implemented the heavy cut law, the General Assembly said by statute that emergency rule can continue on as a permanent rule. So the department thought that that rule was just in place, and they were unaware of the publication requirement for that rule, and they did not file that rule with the Secretary of State. And it's kind of understandable when you look at what the General Assembly did. It said this rule will continue in place, and when I was asked to look at it, I was like, yeah, this is in place. And then I was like, oh, wait a minute. Did you file the rule? And they're like, no, we didn't. And so what they're asking for is to retroactively recognize the application of this rule to 2018, between 2018 and 2025. They've taken no enforcement action under the rule. They're not currently enforcing against anyone. So no one's due process rights have been affected or violated by enforcement under this rule that's technically been repealed. And so what this would do is would restore the validity of that rule going forward.
And can you just remind the committee, briefly summarize the heavy cut rule?
So the heavy cut rule is largely a notice rule. It's if you're going to be harvesting 40 acres or more below at or below the sea line. And the sea line is a harvest threshold where if you go below that parcel is not going to be able to sustain the regrowth of the stand on that level. So basically, the department wants to know when you're going to be harvesting in that threshold, the sea line. And the sea line is a USDA standard for assessment of cut. And it's a notice that you notify the department that you're going to have a heavy cut. They go out, they evaluate the heavy cut or the proposed heavy cut. There's a different threshold if you're going to be over 80 acres. And so that's what they do. When they have enforced over the past 10 to 15 years, they've used the statute and the requirements of the statute to enforce and not the rule. Because the statute is it's a good statute. I didn't draft it, so it's a good statute. Now, one of the things you also need to remember is that most forest land, well, not a good amount of forest land in the state is in current use. And you need to manage your current use land according to a forest management plan, which generally doesn't allow for heavy cut. And so most property where there is harvesting, it's not a heavy cut. It's not triggering a 40-acre sea line cut. But this is to ensure that where there is, maybe up in the Northeast Kingdom, some of the timber harvesting companies there are doing heavy cuts. This is to ensure that the department continues to have the same authority it has had since 1999, I think.
Thank you.
So moving on, most of the rest of this you have already seen. Section 7 is that definition of household hazardous waste producer covered household hazardous products that excludes paint products, because paint is going to be covered in the paint stewardship program. Section 8 through 13 are those conforming amendments to the covered household hazardous product stewardship program. They are the same as what passed 319, including the ability of A&R to issue its own plan if the stewardship organization is not. Section 14 and 15 are the changes to the paint stewardship program, adding those definitions of aerosol coating, non-industrial coating, and I always forget the other one. And then making the conforming change to what is a paint product. This also changes how the paint assessment is determined and assessed going into the future. Remember, underneath the current program, the stewardship organization proposes an assessment to the Agency of Natural Resources, and the Agency of Natural Resources approves the assessment. And then that assessment is charged as a included fee on whatever you pay for architectural paint right now.
So isn't this the part we didn't have in our bill? We asked the Senate to take this up and they added it to 319.
No, what happened is that, yes, you are correct. That is correct. The Senate did put the paint back in. It was in here right up until the fee question came up. And remember, they came in with a range of fees for the new paint products, and you didn't like that.
I don't think we got that far. I thought this was the paint product folks wanted it to just get rolled into the existing paint program, and the SWMI said, well, we need more compensation. And then we said, you need to we took it out and sent it to the Senate. But yeah.
Madam Chair, Allison Crowley
Yeah.
from the American Codex Association. That is correct. We had some discussions with the SWMIs and A&R. We weren't quite there yet, but your committee urged us to keep talking. And in the meantime, because we were running up across the crossover deadline.
Yeah.
So you passed it out without it, but asked us to work on it on the Senate side, which we've done. Very pleased with these results. So yes, now it appears.
Do you have a pathway citizen?
Yeah.
You're there for a while?
Yeah, I'll be there for 3 years.
Yeah, thank you.
So I'm sorry, that is my,
No problem. I just want to be sure because the House hasn't seen it and Representative Sakowicz is going to report on it. And it'll sort of, the depth we go into will be part of that.
If I may, I believe the committee did review the language when it came and you took a straw poll on.
Good.
I believe on the paint, on unanimous straw poll. That's my recollection anyway.
19? Oh,
definitely remember walking through it
Yeah.
with you.
Michael
I
came
think
back and
it's-
walked it through
okay.
and the committee took a straw poll.
did.
And we took a straw poll, but the full House has not.
Correct. Yes,
And-
so
but-
this committee has reviewed it.
Yeah. But so just so I'm clear, we were taking it because we were anticipating 319 coming back, right? Okay, Representative Bartholomew.
The language then that has been moved here is identical to what you presented to us before
Yeah,
in the other bill.
exactly. I think what I need to do in the side by side where it says it's the same text as section 10 and 11 of 319 is passed by it should be as proposed by the Senate.
Yeah.
It's not as passed by the House. I
Okay.
definitely remember walking through that language with you. Sorry, I'm
That's okay. I'm,
exhausted. And then section 16 is Rygate. I think you probably all know about Rygate or heard from Ellen about it, how they have the ability to do efficiency project there to maintain the base load renewable power rate, and they need extra time. They have a new owner. They are pivoting on what the project will be.
right, and we did hear from them as well, and I think it's the same change. It just has to say as passed by Senate natural, I guess. Over in the, because that wasn't in,
Yeah,
we didn't have that in
Yeah.
19.
I will fix that too. And then the effective dates are covered household hazard products, paint and Rygate are effective on passage. The rest takes effect on January 2025, except use value is coming out. So the rest of the actuals shall just take effect on January 1, 2025.
Right, any questions for Michael on these? Or,
January 1, 2025 is already passed.
That should say July 2025. Yep. I have some revisions to do to the side by side.
yes, thank you for that side by side so quickly. Okay, members, so we've already taken a straw poll on those two sections, so you should actually have that. Do you have that? Straw poll results, because we did walk
From
through
those
it.
two sections.
Yeah,
No, I don't
yeah.
think so. So I wouldn't have needed to report if we didn't, if it
Well-
wasn't in the bill.
So what we just went through was we walked through it as past Senate Natural 319 and did straw polls. So we should have those straw poll results. I just don't, with members absent, I'd like us to have as strong a straw poll as we can. So I'd like to figure out who took a record of that, and I'm hoping it's you, although Representative Austin may have. We could also go back and listen to the end of that tape, so we'll figure that out.
I think the only thing you haven't looked at are the pesticides, the Rutland Fair, use value, and heavy cut. Use value is coming out. Pesticides is what it is, and so is the Rutland Fair.
And it seems to me that well, I guess I'm curious if members have concerns about those two proposed amendments. If they seem reasonable to me. Do members need to hear further testimony on those? I'm sure the ag agency will, or committee will also be weighing in on those two, so we'll have to coordinate among ourselves, but Representative North.
Thank you, Chair. I do have a question. Michael, if you happen to recall in section 4 about the stormwater permitting, the way you explained it isn't quite the way I interpreted it here, but what you're indicating is that they are still required to apply for a 3-acre permit from Fair. And thus go through the construction of whatever that permit was for. It's construction of some on-site capability, whatever they're capable of, given the constraints geographically they have. Is that my understanding, that they still have to go through all that?
So what they need to do first is an engineering feasibility analysis. It's what the manual, the stormwater management manual requires for every operating permit. And you identify what you can do on site for for whatever you need to address. It might be stream channel, stream bank, it might be collection. You identify what you can do, and there are alternatives within the manual for what you need to do. And then once you've decided what you can do, You have to determine whether or not you reach your performance goal. And it's not uncommon not to meet your performance goal on site. And that's why there's the impact fee that you can pay or the offset project that you can do in the watershed. The impact fee isn't that like a fee paid to the general fund. It's paid to A&R, and they use that to do projects in the watershed where you're located. So what this is saying is like, maybe they can only get to 60% with their EFA on site, and they won't have to pay a stormwater impact fee to cover the remaining 40.
But they still then would be required to proceed with whatever construction was
You would
identified.
still have to do what is necessary to
Haven't
meet.
they already done something? So that's how how else did they come up with a $3.7 million price tag that they were?
I think they did an assessment. I think they did an assessment, and I think they determined what they could do on site. I think,
And that carried the $3.7 million.
no, well, you would have to talk to A&R, but I think A&R may have suggested a downward estimate. But I think A&R thought that 3.7 might have been too high.
I'm just wondering how much this benefits them or what it really does for them.
It's gonna save them money.
It's gonna save them the engineering study. That was 250,000. That, they couldn't do it. They didn't have them. It'll save them that. It's not gonna save them any money as far as
No, I don't think it
I do think
as far as the compliance.
for compliance, right?
It's not gonna save them.
For what they can do on site.
Right.
But they probably would not have got, they're not gonna get to their performance goal on site.
Can't.
They can't. And so they won't have to pay that additional or do an additional project, which will save them money.
Could they decide based on their engineering assessment that can't do anything? We're not gonna build anything,
Well, now that's,
not pay for 100%?
that card has been played by people before, and the agency has to approve your engineering feasibility analysis. So if you just come forward with like, I can't do anything, the agency will look at it and say, oh, no, you can do these things. That's been tried before.
Also, as I recall, they've had that done. They identified areas they were able to do some.
Identified alternatives that they could have.
Some things are, yeah, and they just couldn't do it all, and this will give them a buy on the remainder. Which it seems like a reasonable compromise.
That's still
And-
3.7 million. At least that was the initial estimate.
It's on them a lifeline for a few years. Unless anything changes, that they're gonna be back to where they are.
It's a lifeline for a few years, but remember, the General Assembly also created the capital construction grant for ag fairs 2 years ago and it's a formula. Formula is in part based on need. So if Rutland has a greater need, everybody gets money. Doesn't take away money from all the fairs. But if they have a greater need, they will be able to get additional dollars over the next. I think the way that the formula works, you only get that priority for a couple of years.
Is that the 2 million that was set aside?
No, this is an ongoing program that gives the fairs money. There's two different programs. There's a capital program and there's an operating program. And the capital goes through the capital bill. I don't know much about that because I don't go to that committee that often. But I wrote the operating grant permit and then provides money to them every year, which they could use. And plus, when there's specific needs, you're usually pretty responsive to the fairs.
Thank you. And I'm actually just looking now at section 3, which is very short. It's extraordinarily short for a study back on an EPR program. So maybe we could just look at that quickly with you. It
Or
is
specifically, like the
it
language.
should be on page 25, yes, of the bill. The bottom of page 25, section 3.
So it's a study that's going to be conducted by the Secretary of Ag in consultation with DEC. And they shall study options for sustainable funding to reimburse solid waste management entities for all costs associated with collection and disposal of the unwanted or obsolete pesticides at municipal hazardous waste collection program and events. The costs to be reimbursed are all the costs that SWMIs always want reimbursed under any EPR program. I won't read through all of them, but that's always what they want. And it includes the collection event, setup fees, service fees, insurance, and shipping containers, because those service fees and insurance fees for these types of products are actually pretty significant because of the harm that can be caused when you mismanage them. And so that will be what they will look at. It will include it says they will include consideration of the viability of an EPR program, but you have to also look at the fee language. In the fee language, it says this additional fee shall be collected from registrants until such time as an EPR program is implemented in the state that fully funds the collection of obsolete and unwanted pesticides. So if they come back with a recommendation that's not EPR and doesn't fully fund, then the fee continues. And it's basically that recommendation will be how they will use the fee to cover the cost of the solid waste management entity. So that's kind of the check. If they're not going to do EPR, then that fee goes forward and pays for the cost of the SWMIs.
And our Ways and Means Committee has already looked at these changes in
Yes.
their entirety, and their only recommendation is the removal of section 5.
Yes. And they otherwise voted 8-0.
Are there further questions on these changes from members? So I think we should take a straw poll on I guess on both of those sections, 3 and 4. We've got 1, 2, 3, 6, 7, 8 of us here. 9, Rep Logan is here. And we'll go back and get our straw poll on the previous sections that we already looked at. So would do members, all those in favor of sections, are people comfortable voting on them together? And are all those in favor of sections 3 and 4, raise your hands.
Could I, it's really sections 2, 3, 4, and 6. Because 5 is use value and that's being removed.
Yeah.
2 and 3 are pesticides. 4 is Rutland Fair and 6 is heavy cut. You have not voted on those previously.
Right. I was focusing on areas that all right, say those, I'll look at the side by side.
So sections 2 and 3 are pesticide. Section 4 is 3-acre Rutland Fair. Section 6 is the heavy cut rule and its continued viability. That's it.
Yeah. Because I feel like we haven't taken any testimony on the heavy cut rule, and that I'm hoping our I'm hoping our Committee on Agriculture has, and is going to be reviewing this with you probably this afternoon. Is that true?
I was scheduled to go in there at 1, but apparently you're going back to the floor at 1.
We are going back to the floor at 1.
So I don't know when I'm going back in.
Yeah, but you'll get to this with them in the afternoon. So I'm feeling like for us, that would be a pretty new topic, and these other topics are and section, so then back to section 2, pesticide disposal, the fee for pesticides. Pesticides typically is Agency of Agriculture, right? But the
Right.
solid waste is.
Solid waste is right.
And so I think it makes sense for us to you're right, add two, 3, and 4 would be where I would be comfortable taking a straw poll. Seems solid waste management entities support, obviously, no, we understand they do a lot of work that's not compensated, and this is a way for them to get compensation for some more of that work. Does that make sense to folks? So I'll just say sections 2, 3, and 4. All those in favor of the amendments proposed here from the Senate on sections 2, 3, and 4, raise your hand. So that is everyone present, and I don't know, Rep. Logan, are you with us? She is behind you on the screen. So 2, 3, 4, 5, 6, 7, 8 in Kate Logan's a yes. She just texted me 9 in favor, and 2 absent. 902 straw poll on those sections. And there's her hand up. Great. All right. Thank you, members. And thank you, Michael. That's it for now. We'll adjourn for the day until further, unless we have something else to take up.
And Representative Sakowitz, I'll correct the side by side and send it to you just in case